Welcome back to the Environmental Law Monitor. I'm your host, Daniel Pope. This podcast is brought to you by Bracewell LLP's Environment, Lands, and Resources Practice Group, and is a place for thoughtful conversations on environmental and natural resources law and policy, ranging from the latest developments to perennial topics like litigation, enforcement, and compliance assurance. We're glad you're spending some time with us today. Thank you for joining us. If you are listening to this episode and it's your first episode that you've heard on government inspections, I would encourage you to go back a couple of weeks and listen to our previous episode. I'm picking up here a conversation with Kevin Collins and Seth Charme. We talked in that previous episode about how to get ready for government inspections. And here we will be discussing what to do when the government is actually knocking on your front door. So I hope you enjoyed the conversations and thanks for tuning in.
And one thing I want to make sure the listeners are aware of is, understanding what authority is being presented to you at the time. And so just to be clear, if armed agents show up with a judicially signed search warrant, you ask for the business card of the lead agent. There will be a lead agent. You can ask for a copy of the search warrant. It won't include the affidavit. It'll just be the search warrant. And you're going to get an inventory at the end, right? But that's not the time to challenge the warrant, right? A judge has already signed off on the warrant. So we're not going to challenge their ability to come in and execute their warrant. For whatever reason, they think they need to execute a warrant. So as long as you see a warrant, it's got a judge's signature on it. The date does not appear stale to you. And that's a little bit of a legal term of art, but generally it's got to be pretty recent. And you get that business card, then you just let them do their business. Now, if you're a refinery or a chemical plant, you may want to let them know, listen, there's some risks out there. We can help you do this and let's work together to do that. But a search warrant is different from an administrative inspection. So I just want to make sure the audience understands if it's men with guns or women with guns and they've got a warrant that's been signed with a judge, that's different from OSHA knocks on the door and wants to come talk to you.
And knowing those authorities, having at least some sense of it, right? Because there's the search warrant, which gives them the authority you're talking about, Kevin. There's the regulatory authority, which essentially you submit to by participating in that industry. There are some highly regulated industries. And if you want to do that kind of business, you waive certain privacy rights and you agree that people can come in and inspect. But then on the other end of that is simply the voluntary search, which law enforcement, if it can't have a compulsory search authority, a warrant or a regulatory authority, very often they will simply do a knock and talk or a Hail Mary, and they'll just say, hey, can we come in and talk to you? And the answer to that question may be a polite no, or a question in return. Under what authority would you like to come in and speak to me? What does this relate to? And if they don't assert some compulsory authority and say, this is purely voluntary, we'd just like to come in and look around and talk to you and maybe look at a few things, and you have reservations about that, I mean, that's what lawyers are for, right? So if there's no exigency, there's no compulsory power, and it's simply a voluntary request, sometimes it's prudent, to buy a little time until you can figure out what it's all about. And that often involves the advice of counsel.
Yeah, that actually kind of gets to one of my next questions, Seth. I'm thinking about even those small and medium-sized facilities that will have, dozens or maybe a few hundred people working at them, but might not have a lawyer hanging around, right? So what are some of the best things to do when an agency comes looking to inspect, or when enforcement authorities come with guns, as Kevin pointed out, to visit the facility? What are some of the things that non-lawyers need to be able to do and need to be confident about while they wait for support from in-house counsel or outside counsel to arrive and assist? Knock, knock. We'd like to tour your facility. Before the lawyers get there, what should the management personnel at that facility be ready to do?
Yeah, I think Kevin's point about safety is really an important one. So, typically we would say don't volunteer information that you're not required to provide. But if there are true safety concerns about the physical space and you're accepting the authority that the agents represent they have to come in, I do think you should feel comfortable giving limited information that creates a safe environment for everyone. You can even ask for some direction from the agents or make yourself, an assistant in helping them do whatever they have the authority to do safely. But beyond that, I think it's important to distinguish between record search authorities or searches pursuant to a warrant for documents and things, and then the rights you may have with respect to statements. So often it's human nature to become alarmed at a surprise event and to think to yourself, if I say a lot of stuff, this is going to go better for me or for the company. I want to appear helpful. I want to create the impression that no one should be suspicious of me. So I'm just going to start babbling information that sounds good to me. That's generally not a good idea. It sounds obvious, but it's human behavior, and we see it over and over and over again. This nervous energy in the room. I wanted to make the agents or the government, think well of me personally or the company. And so I just started telling them a lot of stuff I thought would be helpful. Very often what we find out is it was not helpful. So I think you have to really be thoughtful about any statements that you're going to make. While you may have an obligation to allow them to conduct their physical search, that doesn't mean they have a right to interrogate you about anything that comes to mind. And it certainly doesn't mean you're under an obligation to volunteer everything that comes to your mind.
Narrator, that's a terrible idea to speak. Just to be clear.
That's right. Maybe this is all about becoming comfortable with awkward silences in the most awkward of situations.
Yeah, that's a good point. I mean, I have a good friend who's an agent I worked with, and raising teenage kids. And there was kids asked me one day, "Oh, Dad, the police came down. We were all hanging out down on the pier, and they were talking to me, and I didn't know if I should talk to them." And I had this sort of dilemma. I was like, "Well, geez, I want my kids to be good citizens and respectful of the police. On the other hand, I don't want them to get in trouble." So I asked the agent I was at lunch with, I said, what advice do you give your kids about talking to the police? And he said, "Oh, this is what I tell them. I say, if the police ask my daughter a question, I say, tell them you have something very important you want to say and that they need to record it because it's going to be really, really important. And then as soon as they turn on the recording device, you say, I'd like to speak to an attorney." And I thought, if this is the advice he's given to his kid, maybe there's a lesson to be learned there for all of us.
Yeah. And Daniel, I want to just pick up on one more thought there. In this space where we've got safety and environmental concerns, a lot of it does turn on what you've heard us say: authority. What authority do they have? But it's a complicated, highly regulated area. So let's drill down and think about just one authority for a minute. CERCLA. So if there's hazardous waste there in the facility, CERCLA has some pretty good authority for the government to come in and ask for information or conduct an inspection. And one part of that regulation is the one the government likes to cite to, that basically says, through divine inspiration, we can do whatever the hell we want to do. So get out of our way because you have treated, stored, or, whatever hazardous waste or hazardous materials at this facility. But if you go up about 2 paragraphs, you'll see that's only if there's the risk of a release, right? If there's credible information that there's been some sort of release or some sort of, impact to the environment, that they get that authority. And so, in that instance, understanding the scope of their authority and understanding what has to be proven for them to do what they want to do. And it's very specific when you look at the reg. Their right to enter is pretty broad, but it's contingent upon a legitimate, probable concern about the release of hazardous substances into the environment. And if you haven't had that release, then they can go pound sand. We can look at another example. You've got the Chemical Safety Board, who has pretty broad authority, right? But if you look at their statute, it's only if there's been a fatality, substantial injury, or substantial property harm. And back in the day, they hadn't defined those terms. Now they have now. But if you haven't had a fatality, if the injuries weren't serious, and if you didn't have more than, say, $500,000 in property damage, you could tell them to go away. And in fact, we did that once, and that inspector still sends me a note on February the 12th every year, and he says, "Happy anniversary," because that's the day I threw him out of the refinery. So you just have to know, what those authorities are to be empowered to exercise your rights. And you shouldn't feel bad about it. You have rights, exercise them.
And I think drilling down into your question, Kevin, you brought up CERCLA, and this is maybe more of an environmental question. Agencies will typically perform a CERCLA inspection or a Clean Air Act inspection. They're going to be initiating their inspection under a particular statutory framework. And they could do, multiple ones at the same time, but usually they'll invoke a particular statute when they come and pay you a visit. So they'll visit your facility or they'll request data because they believe that there may be potential violations, and those happen under the Clean Air Act or under the Clean Air Act's regulations. And I think sometimes, apart from the purpose of the search or the lawfulness of the search, I sometimes wonder about, what are you looking for that's relevant to your enforcement authority under that statutory provision, right? And suppose EPA or another enforcement authority wants to collect information, sample, say they come in under the authority of the Clean Air Act and they want to sample a waste stream, right? Or discharge, things that aren't relevant to the Clean Air Act, or at least don't seem to be relevant to what they're looking for. What's the best way to respond to that? Because then you're not dealing with the lawfulness of the entry, right? We're not dealing with questions about the subpoena or the fact that they have a statutory permission to enter. Then we're sort of drilling down into the relevance of their inspection for a potential violation that they may assert. Does that make sense? And what's your response to that? How would you?
Yeah, no, I get it makes sense. It's like I'm going to simplify the question a little bit, but it does make sense to me. So if you have an agency that has authority to investigate A, and then they show up and then they go and they decide they want to investigate D, and you're not entirely certain that D is within the scope of their authority, what can you do? Is that a fair symbology?
Absolutely.
Okay, so let's just take a step back for a moment. They've entered your facility not with a compulsory document, but you've essentially allowed them to come in, right? You've consented to them coming in. So you can end your consent, and you can certainly not consent to this option D that they're working on, right? Say, look, we're not consenting to you doing something that doesn't have anything to do with hazardous waste. You told us you wanted to look at hazardous waste. You either stop doing that, or you know what? Let's just pick up your tools and get out, and you can come back. Go make your argument to a judge as to why you have the authority to do that. And so it's not so much that it turns on the ins and outs of these dense regulations. I mean, in some respects it does, right? What are they allowed to do? But remember, you voluntarily allowed them into your house. You can ask them to leave, and then they can go and get something that compels you to let them back in. And that's may or may not happen. It probably won't under our, hypothetical. But Seth, what do you think?
Yeah, I think that's exactly right. The scope of a search, the authority and the scope are the critically important principles to look at. And authority relates to scope. And as you said, knowing where those boundaries are so that you can assert the rights you have that go beyond the scope of the authority are really, really important. It's hard to do it in practice if you're thinking about it for the first time in the moment, as that search or inspection is unfolding and you're getting that uneasy sense that it's spilling into places it shouldn't go. It's hard to do that in real time if you've never really thought about those boundaries before, thought about how you're going to explain it, and really thought about the fact that there are remedies for the government. Absent some exigency, you ought to be able to take the temperature down that way and say, hey, we strongly disagree with you about the scope of your search and the authority underlying it. And if you want to go further, we'd like to see the authority for that. We'd like to see, some judicial review of that. We'd like to hit pause right now. And then, of course, once they leave, you can't shred anything, right? You're going to have a problem. So we're not talking about evading law enforcement. We're talking about complying with law enforcement, but holding law enforcement to the appropriate legal standards and knowing what the boundaries are ahead of time. And I'll just add that, we started out when the hypotheticals of searches talking about things like, gang violence and GPS trackers in cars. But I want to be crystal clear. Companies that engage in activity that has a potential environmental impact are very appealing targets for criminal law enforcement investigations right now. If I was a young prosecutor again, thinking about the dream case I was going to make, it would probably involve some type of fraudulent statement, public-facing statement about activity that was going on in a company where there was a detrimental environmental impact, and I would charge it as a wire fraud and as many other things as I could think of. And that would be wholly consistent with the priorities that the administration has laid down. The reason I make that point is because you might think, okay, I'm in a regulated industry. I can expect the EPA to come. I understand the EPA's authorities. I can imagine what it is they're looking for. But what in fact happens is an FBI agent knocks on your door and says, we're doing an investigation. We're looking for your assistance. We'd like to come in and talk to you and maybe look at some of your records. And that's not the thing you anticipated. So, obviously everything's a risk-based assessment. You don't want to prepare for things that are almost certainly not going to happen to you. But my suggestion is do contemplate different types of searches because you're going to handle them a little bit differently.
Yeah, and Seth hit on a big issue over the last, I'd say, 5 or 6 years where it's really risen, I think, in focus, and that's lying, cheating, and stealing. Every young prosecutor understands lying, cheating, and stealing. You tell them, well, here's this CERCLA thing, and it's a hazardous substance, but then you got to ship, their eyes glaze over. They have no idea what you're talking about. But if you talk about lying, cheating, and stealing, okay, yeah, we can investigate that. We get that.
Yep. And I think what a lot of prosecutors are doing right now, this is total speculation, but it's what I'd be doing. I'd be looking at the aspirational ESG statements coming out of a lot of companies in this sector. And I'd be asking myself, is that a lie? Are they profiting from that lie? Who's relying on that lie? Because if I can bring an enforcement action against a company that's exaggerating its ESG compliance, I am going to send a tremor, through the industry. And I would think that that's what my command intent is expecting of me. We want you to send some shockwaves to this industry. We're interested in, corruption, lying, cheating, and stealing, as Kevin says. And we're very interested in effects on climate and environment. So again, I never want to be a chicken little sky is falling, type of lawyer. There's plenty of good ways to navigate this. You have time, I think. Our clients, certainly should not, in my experience, fear that, the FBI is staging outside their door, but they should contemplate how they'll handle that if that happens, because there's a right way and there's a way you can really set yourself back.
I want to add something to what Seth was saying, but could you imagine you're publicly traded or not, whatever, you put out ESG statement and you make a claim, you make some objective claim, and you have operations in a environmental justice area of the world where that's a focus from the government. And this will bring it back, Daniel, to your audience. And we're going to talk about documentary requests. That's why I'm going to get us to documentary requests. But the government says, we've read these ESG claims in your annual report, and you talk about all these objective things that you've done and accomplished over the last year, particularly in this area of Louisiana or Alabama or whatever. Produce the documents that support those claims. Right?
Yep.
That's a heck of an information request.
Yep.
And maybe that's what we do now to get us back to talking about information requests. We've talked a lot about inspections and search warrants, but let's talk a little bit about documentary collection. But I just want your audience to think about that. How would you respond to that document request?
Yep.
Let's do.
I'm sorry, America. Didn't mean to give the government a good idea.
No, I'm quite confident they've been thinking about it for the last year or two already, Kevin. But part of the answer to that question, right, is you have to be, I would say you've got to be supporting those, thinking about your nightmare hypothetical sort of in real time. It shouldn't be the heaviest lift that if you're going to make a public facing representation, there's a file somewhere with the support for that and knowing where it is and tying the representation to the support.
Yeah, it's a big red file somewhere.
The more aspirational or hypothetical or conceptual the statement is, the easier it's going to be to deal with it. It's what you identified, Kevin, as those objective, factual representations, that you better have some backstop for. Because I think a case like that would be very, very appealing to the department right now if they could find it.
So, as you point out, we've spent a bit of time talking about inspections. What happens when an agency shows up knocking on your door? But what happens if you open the mail and EPA has requested a number of documents? What are the best ways to push back on what you think are unjustified document requests that go beyond the scope of the agency's authority or go beyond the scope of their actual investigation?
Well, what a timely question, because right before this podcast, I was dealing with that very issue. And again, I'm always interested in Seth's experience here, but from where I sit, I think too many organizations are afraid to just pick up the phone and call the agent or call the authority that sent you the document request. Because you got to understand, these are government workers who are not specialists in your field, whatever that field is, whether it's refining, chemicals, hazardous waste shipments, baseball, banking, whatever. They're not specialists. They may pick up some vocabulary here and there depending on their tenure, but they're not specialists. So they're going to have asked you questions about things that they don't 100% understand. So you should pick up the phone, talk to them, negotiate an extension, because you can't get it done in 30 days. Tell them if you're willing to cooperate, tell them you're willing to cooperate, tell them you're interested in a rolling production, and then go through the 100 requests they've asked you and start to, redefine things and rescope things. And most of the time when I have success doing that, I say, listen, you asked us for flux capacitor. If we give you what you actually asked for, you're going to get like 5 terabyte of information. You don't want 5 terabyte of information. So let's work together to figure out what it is you think you want, and let's call it the right thing. And then we can sample and give you some, and you can review, and you go back and forth until you figure it out. But a lot of it's just defining terms and being willing to, it's not going on the offensive. It's just simply opening up a dialogue and letting them know that they've asked for the wrong things. Seth, your thoughts?
Yeah, absolutely. And it's having the credibility to have that conversation, because ultimately there's an alignment of interest there. I'm far more sympathetic now that I'm on the receiving end of these third-party subpoenas, than I was when I was in the government, and we just kind of launched them, a few a day. And you may have an agent write up a rider, and they often start with things like any and all documents relating to, and then they have a compliance, a response date that's like 30 days later. But the government isn't a subject matter expert on the industry, or frankly, what's likely to be fruitful in that response. They're figuring that out as they go. So if Kevin calls someone in the government and says, I can see why you think you need all this, but let me explain to you how we actually operate, what we actually record. I can empathize with how, a theory you may have about why this might be relevant, but we will begin compiling records that in good faith we believe are responsive, to this subpoena request demand. But can we have an ongoing dialogue with you to make sure that we give you the information that you need to support your investigation? But can we please avoid any undue burdens on us? Surely you'll be sympathetic to the fact that we have to continue to run a company while we comply with your request. And in my recent experience, we had great success narrowing a subpoena, which started out very, very broadly. And we were ultimately able to satisfy the agency that issued that subpoena with a very small amount of information. And along the way, you get to educate the government about your client, about the company, in a way that's helpful. I mean, just to be blunt, you want empathy from the government. You want to say, look, we're a good corporate citizen. We follow the rule of law. We want the bad actor to be brought to justice. But just to be clear, that's not us, And so we will cooperate. We will comply. And look, if you're saying it is us, it'd be helpful to know that, because we will prioritize things. But those conversations that Kevin's talking about, hugely valuable to get an idea of what the government's really looking for. So for the client, extremely valuable. You'll almost always get extensions on the time to comply, at least for the grand jury subpoena, in my experience. And if the government believes that you're in good faith trying to come up with some information that's going to ultimately save it a lot of time and energy, and wheedling it down to what's really relevant, then that can go well for all parties. But what you should not do is just panic and try to hit the deadline in a vacuum, because you'll probably do more work than you need to. And ultimately, the government is usually receptive to these conversations, in my experience, across agencies.
Yeah, particularly if it is a subpoena.
And that kind of connects with an earlier point that you both made. You don't want to provide the government with more information than it needs to conduct the information request that they've given you. And so it's sort of like the awkward talking during an inspection. you don't want to ramble on. You don't want to over provide information that's ultimately not relevant to the claims that they're seeking to investigate.
Yeah, that's why experience on both sides is so critical. You've got to have somebody who can empathize, with the government and figure out what they're really after and what they're thinking about. And you've got to have somebody who knows the client inside and out, knows the business operations, the commercial interests, the reputational interests, what the resources are to even undertake an effort if the demand is overly broad. So you've really got to have somebody who knows both sides of the court.
And I think, I know we're running late here, but I think too, if you have an information request that occurs simultaneously with the lawful inspection, right? They've come in and they're conducting their inspection. I would just caution our audience to not over lawyer the presence of those inspectors in the facility. When I think about it, I think, okay, how do we define success for this facility? They want to be back online, producing, making money. They need to repair things if there's been an explosion. There's other things they want to do than have a bunch of inspectors sitting at their facility for weeks or months on end. Well, one way you can speed that up is if they ask lawfully to look at your process hazard analyses for the last 2 years or 4 years, which they have a right to do. And, those are usually in some binders in somebody's office, and they're big, thick 3-inch binders, and there might be 6 of them. You don't have to bait stamp all that stuff before you show it to them. There's nothing in there that's privileged, right? It's not privileged. You had to do it. There's a regulation that says you have to do it every 5 years, and you got to keep them for so long. So you park them in there, put somebody there to monitor them, and say, have at it. And if you see something that you care about, tell us. We'll pull that page out. We'll photocopy it. We'll bait stamp that page or that section, and we'll send it to you when you're done. And you will not only get to be on their good side, but you'll get them out of your facility, which I think is really what the goal should be.
Yeah. And that's a good, it just makes me think, Kevin, it should go without saying, but keeping your house in order will make this all go a lot more smoothly. So if you can limit the physical scope of their search, because you can readily either produce the thing that they've asked for or take them into, a room which is essentially compartmentalized from other areas that it would exceed the scope of the authority or the interest of the government, that's a good idea because, you don't want them stumbling into things which can just expand the course of an investigation.
Because I'll tell you, you tell those inspectors, we'll get you those PHAs, but we got to have lawyers look at them and then bait stamp them. And so those guys sit there for like a week. You know what they do? They write more information requests because they don't have anything else to do. You haven't given them a chance to look at the documents that ultimately they're going to look at and be done with pretty quickly. So all you do is propound the problem, right? Creative agents will just sit there and go, well, you know what? What about this? What about this? What about this? And then it gets worse and worse and worse.
That's a great point.
Well, thank you both for joining us today on The Monitor. It's been a great conversation. I think I've learned a lot. I'm sure that our clients and our guests and listeners will learn quite a bit as well. I always think that having conversations at your facility about these types of scenarios, whether they're inspections or document requests in advance, is just a great idea. And call Kevin about that, call Seth about that if you would like some assistance, and they'll help you, to borrow a phrase from Kevin, wise up. So thank you both. That's it. That's it for us today at the Environmental Law Monitor. Big thanks to our guests, as well as Dorn, Julia, and Emily, and the rest of our production team who helped to make our podcast possible. And of course, you, our listeners. We'll talk to you soon.